Hello and welcome. My name is William Perkins, and I will be your personal guide to help you prepare for a very important journey. A journey that, if taken seriously, will provide relief from what seems to be insurmountable debt and provide you with the knowledge you need to become financially fit. This brief presentation will assist you to better understand what lies ahead. Under the new bankruptcy law, significant requirements are mandated for you as well as your attorney. Your attorney or legal advisor may have already indicated to you that filing bankruptcy has become more complicated since the recent changes in the bankruptcy law. One change that you must be aware of is that any individual who files bankruptcy on or after October 17, 2005 must undergo a budget briefing session with an approved nonprofit credit counseling agency. This recent law change was signed on April 20, 2005 by President George W. Bush as part of the new Bankruptcy Abuse Prevention and Consumer Protection Act. Before starting, I need to mention that it is very important that you, the person watching this presentation, is the actual person that plans to file bankruptcy. Having another person watch this presentation for you may be considered fraud and could affect your ability to file a bankruptcy petition. If you are considering filing a joint petition, then of course you can watch with your partner. Now that we have established why you are watching this presentation, it's time to begin. Before you file bankruptcy, it's required that you understand all your options. In this presentation, I will cover 4 distinct topics which will include various options that you need to understand regarding your current situation. This presentation will take about 30 minutes. Part 1. The basics of credit counseling. In this part, we will briefly explore the basics of credit counseling. You will learn what is credit counseling, what is a debt management plan, what is a 60/60 settlement plan, what is credit counseling. Credit counseling was developed in the 1960s by creditors as a tool to help those individuals with problems managing their money and paying their monthly bills. Credit counseling is available by non-profit consumer credit counseling organizations throughout the country. These organizations offer their services in local offices and also by telephone. They are not lending institutions or collection agencies. They provide free community services and education courses that relate to various financial matters. These organizations can also offer you 2 specific types of debt relief programs. Let's take a moment to review the different plans. Debt management plan. A debt management plan would allow you to consolidate all of your credit cards, medical bills, and other unsecured debts into one monthly payment. In most cases, your monthly payments would be somewhat reduced. You are still responsible for the entire debt, but many creditors provide concessions regarding interest rates and will bring your account back to a current status. Each creditor is different, and the actual benefit would fluctuate significantly from creditor to creditor. A debt management plan typically can consolidate only unsecured debt. You will still be responsible for negotiating terms with secured creditors. Debt management plans will usually only work with unsecured accounts that are past due, such as credit cards, medical bills, department store cards, gasoline cards. A debt management plan cannot address secured debts like house payments, car payments, charged off accounts, seriously past due collection accounts, lawsuits and judgments, child support and alimony, student loans, past due taxes, and bills that are secured by real property. The credit counseling agency can also offer you a modified type of debt management plan that is sometimes called a 60/60 settlement plan. Let's discuss this briefly. A 60/60 settlement plan would allow you to settle 60% of your unsecured debt and pay it over 60 months. The recent change in the bankruptcy law allows the credit counseling agency to offer a 60% payment to your creditors over a 60-month time frame. This 60% proposal does not guarantee acceptance, and the creditor may counter with an amount that they would accept that is higher than a 60% proposal. Meaning, if you owe $1,000 on a past due credit card, you could offer to pay 60%, which is $600. That $600 will be paid over 60 months. Keep in mind that not all unsecured creditors accept a 60/60 settlement plan. Secured accounts like your house and your car do not qualify for a 60/60 settlement plan. Also remember that while creditors will reduce interest many times when you are in a DMP plan or a 60/60 plan, they usually do not eliminate the interest entirely. A legitimate credit counseling organization will also offer you significant educational resources and budgeting assistance. The credit counseling's main objective is to provide you as much relief as possible from your existing debts, and then provide you a budgeting mechanism to deal with your other debts. Credit counseling is one option, an option that may not be helpful to you. No matter how good an agency is, if you just don't have enough money to pay even the renegotiated amounts, or if your debts are substantially secured by assets, then a credit counseling program may not be the right option for you. This concludes the basics of credit counseling, and we will now continue to Part 2, the basics of bankruptcy. Part 2, the basics of personal bankruptcy. In this section, we will briefly explore the basics of personal bankruptcy. You will learn, what is bankruptcy? How does Chapter 7 bankruptcy work? How does Chapter 13 bankruptcy work? What is a bankruptcy discharge and how does it operate? What is a reaffirmation agreement? How to reestablish credit after bankruptcy? What is bankruptcy? Bankruptcy is a federal law that allows individuals over the age of 18, married couples, and businesses to eliminate or restructure their past due debts when they have financial difficulties. Because it is a federal law, it applies throughout the United States. Individuals experiencing significant financial difficulty may consider bankruptcy as an option. When you file bankruptcy, it must be determined which bankruptcy type best suits your situation and which type you qualify for. There are generally two different types of bankruptcy for individuals. They are Chapter 7 bankruptcy and Chapter 13 bankruptcy. How does Chapter 7 bankruptcy work? Chapter 7 bankruptcy is the most common form of bankruptcy. This type of bankruptcy is known as straight bankruptcy. To file this type of bankruptcy, you may seek the help of an attorney or legal professional, choose to go it alone, or use a self-help service company. It is critical that you or your attorney are diligent about gathering your information, preparing it carefully, and following through on details. When you file Chapter 7 bankruptcy, a court-appointed attorney, known as a trustee, is appointed to assess your financial situation. The trustee is working on behalf of your creditors. The trustee may decide that some of your assets must be liquidated to satisfy your creditors. You may be able to keep some personal items, and possibly real estate, depending on the law of the state where you live. Now let's review how a Chapter 13 bankruptcy works. Chapter 13 bankruptcy is also known as wage earner bankruptcy. With the help of a bankruptcy attorney, you would file a proposed Chapter 13 repayment plan to the court. In a Chapter 13 bankruptcy, you can usually keep your property, but you must have regular income and may not have more than a certain amount of debt as set forth in the Bankruptcy Code. Repayment plans in Chapter 13 can range from 10% to 100%, depending on the debtor's income and the amount and nature of the debt. The court must approve your repayment plan and your budget. If approved, a trustee is appointed and will collect the payments from you, pay your creditors, and make sure you live up to the terms of your repayment plan. Your Chapter 13 bankruptcy must be completed within 3 to 5 years. You will also be required to submit updated financial statements to the court annually. Chapter 13 bankruptcy has so many unwritten rules and local customs that you should seriously consider seeking a bankruptcy attorney. What is a bankruptcy discharge? A discharge is a court order which states that you do not have to repay the debts included in your bankruptcy filing. Some debts cannot be discharged. For example, most taxes, child support, alimony, most student loans, court fines and criminal restitution, and personal injury caused by driving drunk or under the influence of drugs. The discharge only applies to debts that originated before the date you filed your bankruptcy petition. Also, if the judge finds that you received property inappropriately, that particular debt may not be discharged. It is important to list all your property and debts in your bankruptcy schedules. The judge can also deny your discharge if you do something dishonest in connection with your bankruptcy case, such as destroy or hide property, falsify records or lie, or if you disobey a court order. Some creditors hold a secured claim. For example, the bank that holds the mortgage on your house or the loan company that has a lien on your car. You do not have to pay a secured claim if you included that debt in your filing, but the creditor can, and quite probably, will take the property. You can voluntarily pay any debt you wish to pay. If you decide to pay a debt and keep it out of your bankruptcy filing, you will have to sign a reaffirmation agreement. What is a reaffirmation agreement? A reaffirmation agreement is a promise to pay a debt that was not included in your bankruptcy filing. Some people may have a special reason why they want to keep the debt and ultimately pay it. For example, you may want to work out a plan with the bank to keep your car. To promise to pay that debt, you must sign and file a reaffirmation agreement with the court. Reaffirmation agreements are under special rules and are voluntary. They are not required by bankruptcy law or by any other law. Reaffirmation agreements must be voluntary, must not place too heavy a burden on you or your family, must be in your best interest, and cannot be canceled any time before the court issues your discharge or within 60 days after the agreement has been filed with the court, whichever gives you the most time. If you are an individual and you are not represented by an attorney, the court must hold a hearing to decide whether to approve the reaffirmation agreement. The agreement will not be legally binding until the court approves it. If you reaffirm a debt and then fail to pay it, you owe the debt the same as though there was no bankruptcy. The debt will not be discharged, and the creditor can take action to recover any property on which it has a lien or mortgage. The creditor can also take legal action to recover a judgment against you. Filing bankruptcy is not the end of the world, as you may have heard. Believe it or not, there is life after bankruptcy. The good news is, even after bankruptcy, you may not have to survive without credit. Filing bankruptcy does not prevent you from getting new credit. In fact, a special type of lender markets their service to recently bankrupt individuals or families. Furthermore, the Bankruptcy Code protects debtors from discrimination based solely on a bankruptcy filing. You cannot be legally terminated or denied credit solely because you are a debtor in a bankruptcy proceeding. You can, however, be turned down based on your total financial history. Before you begin creating new debts, it is wise to remember that too much credit may be the very thing that led you to the bankruptcy in the first place. Most experts suggest that in the first couple of years after a bankruptcy, you avoid making any substantial financial changes. Bankruptcy is designed to lift the financial burden from your shoulders and give you a fresh start to rebuild your credit. If bankruptcy is ultimately your best option, the first step to rebuilding your credit after filing is to stop listening